Hello and welcome to week 5. This week we're looking at contract construction and exclusion clauses. So let's first talk about contract construction. Once the terms of a contract have been identified, the question arises, what do these terms mean? This is particularly an issue if the parties are in dispute. Construction refers to the process by which courts determine the meaning and legal effect of the terms of a contract. It is also referred to as the interpretation of a contract. Disagreements between parties about the meaning of the terms of a contract come about because at the time the contract is made or drafted, parties cannot foresee all the events that will go on to influence and affect the performance of that contract. Let's say you enter a written lease agreement, which stipulates that no pets are to be kept on the premises. But after a few months, your sister, who is living with you and whose vision is impaired, acquires a seeing eye dog from Vision Australia. Your landlord tries to evict you both, stating that you have breached the lease. But you argue that a seeing eye dog is a therapeutic aid and not a pet. Who is correct? Is the seeing eye dog a pet within the meaning of the lease agreement? What is the proper construction of that clause? What kinds of factors will the court take into account? If you discuss the possibility of getting a seeing eye dog with the landlord before signing the lease, is this evidence admissible in interpreting that clause? Can you get around the parole evidence rule? And if it is determined that a seeing eye dog is a pet and you've breached the clause, was it the type of term that would allow the landlord to terminate the lease agreement and evict you? Was it a condition as opposed to a warranty? Or was it an intermediate term? After completing this topic, you should be able to explain the primary approaches taken by the courts when they interpret contracts. You should be able to understand and apply the parole evidence rule. You should be able to classify terms according to their significance and outline the remedies that are available to an innocent party if each type of term is breached. And you should be able to use what you have learnt to ensure that the contracts you, your clients or your employers enter into, reflect your wishes and protect your interests. This week, we also look specifically at one type of term, that is exclusion clauses. We have touched on these before. We discussed them briefly when we looked at the contract precondition of certainty and the way in which a very wide exclusion clause might operate to make a contract illusory. And last week, we considered what might need to be done to sufficiently incorporate an exclusion clause, or an otherwise unusual or onerous term, into a contract. An exclusion clause is a term that seeks to exclude or limit liability for a civil wrong, such as breach of contract or negligence. They are used, for example, in the fine print of contractual documents, on signs and notices, and on the back of tickets, or within the indecipherable detail of an online click-wrap contract. Exclusion clauses are common. Consequently, when examining a contract to determine the rights it creates or the obligations it imposes, it is essential to look at the combined effect of the substantive provisions dealing with these matters and any exclusion clause it contains. Although our focus in this unit is on the use of exclusion clauses in contracts, it should be noted that they can also be used in non-contractual settings as well, such as to limit a person's liability to visitors of their property, or to limit a council's liability to people using facilities such as a public park. Exclusion clauses can be best justified or rationalised when they're used in transactions between two businesses of fairly equal strength. Here, the courts might infer that the exclusion clause is simply a way of most efficiently allocating risk in a relationship. However, they become more contentious when they're used to limit a business's liability to a consumer. For this reason, legislation has stepped in to protect ordinary people from having their rights completely quashed by an expertly drafted exclusion clause. After completing this topic, you should be able to outline the different types of exclusion clauses commonly in use in Australia and how they operate. You should be able to explain what must be done to ensure that an exclusion clause forms part of a contract and is effective. And you should be able to describe why exclusion clauses are used in consumer and commercial transactions and understand and apply the devices used by the courts and statute to control the use and operation of exclusion clauses. That's all from me for now. Good luck getting through the reading, and I'll see you in class.